Before we begin the webinar, we'd like to acknowledge the traditional owners of the lands from which we are broadcasting and from where you are joining us today. I'm broadcasting from the lands of the Widjabul people of the Bundjalung Nation here in the beautiful Northern Rivers. We pay our respects to the elders of the land, both past and present, and we extend that respect also to any Aboriginal or Torres Strait Islander people joining the webinar or watching the recording. Welcome to this Legal Aid New South Wales webinar on convictions, criminal records and their consequences for young people. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. The webinar will run for an hour, including time for Q&A, and in case you've just joined, we ask you to use the Q&A box to ask your questions. After the webinar concludes, you'll receive an evaluation survey, and we do appreciate your feedback and take it into account in our planning for topics for webinars and podcasts in our Law for Community Workers series. You'll also receive an email following the webinar with some resources and handouts that Jane has prepared. Now I'll introduce you to your presenter for today, Jane Sanders from the Shopfront Youth Legal Centre. Thank you, Jane.
Hi, everyone. Thanks, Bridget, for the introduction. This first slide just tells you a little bit about the Shopfront Youth Legal Centre if you don't already know us. We are based in the inner city of Sydney on Gadigal land, and that's where I am today. I'm not going to read out what's on the slide. I think you can read it, you get the general idea. Perhaps the next slide, Bridget, about what we do. So we provide a range of legal services, including court representation on criminal matters. We work with under 18s and also 18 to 25s. We get a lot of questions from young people about their criminal records and a lot of questions from youth workers and others. So this presentation today is based on, I'd have to say, quite a few years of experience in this area. Now, before we go on, there's a couple of people joining us from Kaurna country in Adelaide. Just make sure you know that the law we're going to talk about here mostly relates to New South Wales only. There's a little bit of information about the Commonwealth spent convictions scheme, but just have in mind that we're mostly talking about New South Wales law here. Okay, so next slide, Bridget, if you wouldn't mind. So these are some of the topics that we are going to run through. Just a warning that it is really quite confusing. Hopefully I'll be able to break it down for you a little bit more. After the webinar, as well as getting a copy of the slides, you will also get a copy of a document, a handout, which is it'll look a bit like this. You probably can't see it. It's quite long. It's about 14 pages. It's sort of packed with information. So if you want more information after the webinar, then you'll have access to that as well. So we're going to be starting off, I suppose, on what is a conviction, what is a criminal record, when does a court record a conviction, what does it mean, and what could the impacts be. So let's start off with the next slide, which is what is a conviction. Now, the word conviction is used to mean different things in different contexts. It often is used to mean that someone's been found guilty, like the jury convicted the accused of armed robbery, okay? The opposite of that is acquitted, meaning found not guilty. So if you talk about being convicted of an offence, it might just mean being found guilty or pleading guilty. But there's a second step to that. There's a finding of guilt, but then there is also a formal conviction that the court records. And it's the formal conviction usually that gives you a criminal record. Okay. Now, mostly, at least if you're an adult, if you're found guilty, a formal conviction will automatically follow. Although there is a discretion. A lot of you would have heard of Section 10. That gives the court a discretion to record a finding of guilt, but not recording a formal conviction. For children, there is a lot more discretion not to record a formal conviction. So mostly in this webinar, when we're talking about a conviction, we're talking about a formally recorded conviction. And just to make it even more confusing, even if a court doesn't formally record a conviction, sometimes the Criminal Records Act will treat it as a conviction anyway. So we'll get onto that in a little while, okay? So convictions, that's what it means. Oh, there's just a question here. I'll deal with it now quickly. Do we give services to international students? Yes, we do, if they're within our criteria, if they're experiencing homelessness, if they're disadvantaged, if it's an area of law that we have some sort of expertise in. So yes, we do. Okay. So next slide, Bridget, if you would. Okay. Now, there's a few things that are definitely not convictions, right? So let's just go through those here. So things that never go to court in the first place, such as getting an on-the-spot fine, a penalty notice or infringement notice. Typically, you would get that for a parking offence or a speeding offence, or if you're a young person travelling on the train without a ticket, riding your push bike without a helmet, there's hundreds or even thousands of offences you can get a penalty notice for. If you choose to take it to court, if you do the court election and you plead guilty or you get found guilty, then you could end up with a conviction. But if you just have a penalty notice, whether you pay the fine or not, that's not a conviction. One of the diversionary options under the Young Offenders Act for under 18s, a police caution, an informal warning, being referred to a youth justice conference. That's not a conviction either. A Section 14 application, I think quite a few of you probably knows what that is. It's a diversionary procedure available in a local court or children's court for somebody with a cognitive impairment or mental health impairment. That generally results in the charge being dismissed, usually on conditions, but that does not amount to a conviction either. Obviously, or I think it's obvious, but for some other people, a finding of not guilty, that's not a conviction, right? That's the opposite of a conviction. That's an acquittal. Pending charges which haven't yet been proven, also not a conviction. Or a lot of these things will actually appear on your criminal history, but for reasons I'll go into soon, a criminal history is not quite the same as a criminal record. So some of these things can still be taken into account for certain purposes, like maybe the working with children check, or applying for maybe a security license or a firearms license, or a job where you need a very high level security clearance. So having received some of these things might affect you in some way, but they're not convictions. The final one on the list, an AVO, is not a conviction. An apprehended violence order application is not a criminal charge. An apprehended violence order is not a conviction, right? To have an AVO made against you does not make you guilty of a criminal offence. It does not give you a criminal record, okay? If you breach an AVO, that's an offence, okay? And often it gets confusing because people who have AVOs taken out against them, often they do have related criminal charges. So you might be charged with a domestic violence, assault, or intimidation or something like that. And as well as charging you for the offence, the police will also make an AVO application. So those two things will run side by side. But an AVO on its own, not a charge, not a conviction. Okay. Next slide, please. Okay. Now, myth busting. A lot of young people that we work with seem to think that their criminal record magically disappears when they turn 18. Some of them even talk about their record being sealed, which, as far as I can tell, is an American concept. So the answer is no, it's not that simple. If you've been dealt with under the Young Offenders Act, so a warning, a caution, or youth justice conference, it's true that that does not form part of your criminal record. It can be taken into account by the children's court if you're going to court for you could commit more offences and you go to the children's court. It can't be taken into account by an adult court. So yes, those diversionary options, it is partly true that they don't carry on with you for life. But anything where you actually go to a court, the children's court, and you get a sentencing outcome, even if it's a caution, that can stay with you, depending on the type of the offence, the type of outcome, and whether you're able to stay out of trouble for a few years. Okay. Next one. Okay. So when will a court record a conviction? So firstly, for a conviction to be recorded, there has to be a finding of guilt, okay? So mostly that's going to be a plea of guilty, but it might also be you're found guilty at a hearing or a trial, okay? Or you might even be found guilty in your absence. In the local court, you don't turn up to court, the court can find you guilty based on just the police fact sheet. Okay, if that happens to you, you can make an annulment application to try to have that conviction undone and to start again if there's a good reason why you missed court or whatever. Okay, but so there's got to be a finding of guilt, and then really it's automatically a conviction is recorded for an adult unless the court uses its discretion not to, okay? So the main way the court cannot record a conviction is if they use Section 10 of the Crime Sentencing Procedure Act, okay? So Section 10(1)(a) means it's just being dismissed. There's a formal finding of guilt, but no formal conviction. That's it. Or the court can use Section 10(1)(b) to put you on a conditional release order, which is just basically it's a good behaviour bond. So they can put you on a conditional release order for up to 2 years. It could be 6 months, 12 months, 18 months, 2 years, whatever, without a formal conviction being recorded. Now, for Commonwealth offences, and I'll just explain briefly what that means, most criminal offences are created by state laws, okay? So the New South Wales Crimes Act, the Drug Misuse and Trafficking Act, the Summary Offences Act, Graffiti Control Act, Road Transport Act, they're all New South Wales Act with lots of offences in them, okay? But there are a few offences which are created by Commonwealth Acts, or federal is another word for it, meaning that they apply all over Australia and also in external territories and things. So those kind of Commonwealth Acts include the Commonwealth Criminal Code, the things like the Customs Act, the Social Security Act, the Income Tax Assessment Act, things like that. The most common Commonwealth, the sort of Commonwealth offence that young people often get charged with is what we call use carriage service, okay? So the Commonwealth government in Canberra has power to make laws about telecommunications, okay? So the Commonwealth Criminal Code has got a whole bunch of telecommunications offences in it, including one which, if you're using any kind of online or phone or SMS or whatever, in any kind of similar service, to menace or harass someone or to be really offensive. That's a Commonwealth offence. So quite often our clients get charged with use carriage service, you know, when they send threatening or offensive text messages or social media posts or whatever. So if you're charged with a Commonwealth offence, the court has a similar power to Section 10, but it's Section 19B in the Commonwealth Crimes Act. Now, there's also the Mental Health and Cognitive Impairment Forensic Provisions Act, Section 14 and 19, which I mentioned a couple of minutes ago. Now, that is a diversionary procedure that can be used at any stage of the court proceedings. It doesn't require you to enter a plea. It certainly doesn't require a finding of guilt. So ideally, if somebody's going to be dealt with under Section 14 or 19, it will be done at an early stage without any plea, without any finding of guilt, okay? But I've put this in here because the court still can use Section 14 or 19 even after the person's been found guilty or pleaded guilty, okay? So if they decide to divert the person under Section 14 or 19 after a finding of guilt, then there won't be a formal conviction recorded, okay? Next slide, please, Bridget. So for children, I should also add that Section 14 and 19, those mental health and cognitive impairment diversionary procedures, they also apply in the children's court in the same way as they do in the adult court. But in the children's court, when you have a formal finding of guilt, for a child under 16, the children's court doesn't actually have any power to record a formal conviction. And I think that means under 16 at the time of sentencing. So at the time the court proceedings are finalised, not at the time of the offence. If the young person is 16 or over, then the children's court has discretion. They can decide whether or not to record a conviction, okay? And that doesn't matter whatever kind of sentencing option they get, right? Even if they get a control order, which is detention, the court can still decide not to record a conviction. The next thing is children being dealt with in the local court. Now, some of you might know that if you are old enough to have a licence, which means a learner's licence, that means 16 for cars or 16 and 9 months for motorbikes. If you're old enough to have a licence, the law says you're old enough to be treated like an adult if you commit traffic offences. So if you're basically 16 or over, and you're charged with a traffic offence, you will usually go to the local court, okay? The exception is if there's a related criminal offence. So for example, if you're actually accused of driving a stolen car, that's a criminal offence, not a traffic offence. That will go to the children's court. And if you're also unlicensed and whatever, or you know, you have prescribed concentration of alcohol or drugs in your system, if you've got a criminal offence that's linked to it, you'll go to the children's court. But if it's only the traffic offence without the criminal offence, you'll go to the local court. Now, the local court, when dealing with a child for a traffic offence, they can use either adult or children's court sentencing options. If they use adult sentencing options, then they can use Section 10 if they want. If they use children's court sentencing options, then they've got discretion whether to record a conviction or not. In the district and Supreme Court, so some criminal charges are too serious for the children's court. Things like robbery when you're armed with a firearm, aggravated sexual assaults, murder, manslaughter, commercial drug supply, those kinds of offences, they will be dealt with in a superior court. And the court can record a conviction no matter what the child's age. And I think for certain kinds of offences, the district and Supreme Court has to use adult sentencing options. And I think that means that there will always be a conviction recorded unless they decide to use Section 10. Okay. So sorry if that's a little bit complicated. It is explained a bit more in the handout that you'll get. But if there's any one takeaway message, it's pretty complicated. A young person probably won't know whether they've got formal convictions or not. And it's always a good idea to refer young people for legal advice in this sort of situation because it's tricky. Okay, next slide, please. Okay. Okay, now here's where it gets even more confusing and a bit unfair as well. So the Criminal Records Act in New South Wales covers what goes on your criminal record and how long it stays there, who's allowed to see your criminal record, what kind of things can be disclosed, okay? So basically, what the Criminal Records Act says is that pretty much any finding of guilt in a court is treated as a conviction for the purpose of the Act, right? However, most convictions can be spent, which means being wiped off your criminal record. Some convictions, for example, if the court dismisses your charge under Section 10, are spent immediately. Okay, so it's deemed to be a conviction, but it's also deemed to be immediately spent, which means it's not part of your criminal record. If the court gives you a Section 10, but with a conditional release order, so like a good behaviour bond, then the Criminal Records Act says it's a conviction while the bond is still in force. It's deemed to be a conviction, but it's spent once you've completed the bond, hopefully without breaching it, which is pretty unfair when you think about it, because one of the main reasons a court decides not to record a conviction is so that the person, doesn't lose their job or, is not disadvantaged in things like looking for work or travelling or whatever. But the Criminal Records Act deems it to be a conviction while you're still on the bond. So, oh, great, it'll be spent in 12 months, but meanwhile, you've already lost your job because you've got a conviction. So the way the Criminal Records Act operates is quite unfair in some cases, but it's what we're stuck with for the moment. So that's just what we have to work with, and we have to just learn to understand it as best we can. Now, there's also, for Commonwealth offences, spent convictions for Commonwealth offences are dealt with a little bit differently. Basically, any finding of guilt is also deemed to be a conviction. They can also be spent, but waiting periods are different, different categories of offences which can and can't be spent. I'm not going to go into detail about that. Okay, next. Okay, so as I said, most convictions can be spent, meaning wiped off your record, either straight away or at the end of a bond or after a crime-free period. But there are some offences where the convictions can never be spent, okay? If you have received a full-time prison sentence of more than 6 months, so not a control order as a child, we're talking about an adult sentence of imprisonment, a sentence of 6 months or more will mean the conviction can't be spent. Now, the 6 months refers to the head sentence, not just the non-parole period. What that means, and again, I don't know your level of knowledge, but some of you may know that if the court is imposing a custodial sentence, a prison sentence for adults or a control order for a child, if the sentence is more than 6 months, then they split it into a non-parole period and a period on parole, okay? So the total of those two is called the head sentence, right? And it's the head sentence that matters here. So say you get a head sentence of 9 months, okay? The non-parole period is only 5 months, and then you're 4 months out on parole. So even though you only spend 5 months inside, because the head sentence is more than 6 months, then it means your conviction can't be spent. Okay. Other convictions that can't be spent is convictions for sex offences. Okay. And that includes a wide variety of things, not just rape and sexual assault, but things like sexual touching, I think indecent, or what's it called? Willful and obscene exposure. So if you're caught, dropping your dax to have a pee, in a public place or whatever, usually police will charge somebody with offensive conduct in that situation. Offensive conduct, that's fine. That's not considered a sexual offence. But if they charge you with willful and obscene exposure, then I think that is considered a sexual offence. So anyone who's charged with willful and obscene exposure should always get legal advice and maybe try to offer a plea of guilty to offensive conduct instead. So there's sort of some of the ins and outs. There was a parliamentary inquiry quite a few years ago which recommended that sex offences committed by children should be capable of being spent. And this was a few years before we had the similar age defence. So a lot of children, 16 and 17-year-olds, were being criminalised for having sexual relationships consensual relationships with their partner who was 15, right? They were very similar in age and maturity. It was age appropriate. It was consensual, but because one of them was under 16, then the older one was committing an offence. I think that this parliamentary committee overwhelmingly recommended that certain kinds of offences committed by children should not result in convictions that stay with you forever. Unfortunately, though, that the Criminal Records Act still hasn't been amended, and so we are still in this situation where if you're dealt with for a sex offence, even if the court has decided not to record a formal conviction, it's deemed to be a conviction and it's never spent. It may also include things like child abuse material, so child porn. So I think young people also could inadvertently be caught up in that for sexting or whatever. So it's pretty harsh. Okay. But next slide, please. Turning back to convictions which can be spent. I think I've already covered the first couple of scenarios. Now, for anything where a formal conviction has been recorded by the court, so the first two dot points don't apply, then you have to wait a few years before your conviction is spent. If it's a children's court conviction, then it's 3 years, and it's got to be a crime-free period. So what that means is 3 years when you haven't been subject to a control order or a sentence of imprisonment, or you haven't been convicted of an offence punishable by imprisonment, or you haven't been unlawfully at large, which means basically on the run, like you've got a warrant out for your arrest or something, okay? So if you're able to sort of stay crime-free for 3 years, your conviction will be spent. It will be wiped off your record. And even if you later get into trouble again, that spent conviction won't be revived by crimes you might commit later on, okay? So it means once it's spent, it's no longer on your official criminal record. Spent convictions can be seen by courts. So in that scenario, even if your juvenile conviction is spent and you can tell the world, I don't have a criminal record, if you later get into trouble for whatever, say that you're dealt with as an adult for shoplifting or whatever, the court will still be able to see your juvenile criminal history. And they'll see that when you were 16, you were given a probation order for robbery in company or something. Okay. So it's complicated. So I'm sorry if I'm confusing you. But as far as your formal criminal record is concerned, a conviction spent after the crime-free period and it doesn't get revived later on. For adults, that crime-free period has to be 10 years, which is quite a long time. But it's, you know, if you're in trouble when you're 18 or 19, you can have a clean record by the time you're 30 and you still have a lot of years ahead of you. Next slide, please. Okay. Now, as I said, under Commonwealth law, so if you've dealt with for Commonwealth offences, they've got a slightly different spent conviction scheme. They don't seem to have as much of a limit on what convictions can't be spent, right? It's if you were sentenced to imprisonment for more than 30 months, it can't be spent. And then otherwise, there's a waiting period. For children, the waiting period's 5, not 3. For adults, it's also 10. And I think there's a section in the Commonwealth Crimes Act which basically says if your situation's covered by both the New South Wales and Commonwealth spent conviction schemes, you basically get the benefit of whatever is the most favourable scheme. But it kind of gets complicated, and I think it's a bit beyond the scope of this webinar, but just so you know that exists. Next slide, please, Bridget. Okay. There's also a question on the chat. Does a young person need to action anything at court to have a past conviction spent, or does the system automatically amend records? It's the latter. The system automatically should just wipe it off the record and deem it to be spent. But occasionally, they get it wrong. And so if you think that your conviction should be spent, it is sometimes a good idea to write to the Criminal Records Unit at the New South Wales Police and just double check that that's actually happened. Okay. Okay, so what does it mean if your conviction is being spent? What it means is that officially, as far as the outside world is concerned, you don't have a criminal record. So for most purposes, if you're applying for a job or whatever, answering questions, if you're asked, do you have any convictions or have you been convicted of a criminal offence, you can answer no, okay? There are some exceptions though. There are some types of jobs or professional, memberships of professional associations or licenses to, for example, to work as a security guard or a real estate agent, working with children, check. Some of those things can require you to still disclose spent convictions, okay? So generally, you haven't got a criminal record, but if you're covered by a situation where you are required to disclose spent convictions, that they will tell you. And if you're not sure, you should always try to get legal advice, okay? Now, as I said before, even if your conviction is spent for the purpose of your formal criminal record and what the outside world is allowed to know, courts always have access to any finding of guilt that's ever been made against you, okay? With some exceptions for juvenile children's court outcomes, if there's been a bit of a break where you've been out of trouble, there's some restrictions on what adult courts can and can't see. But generally, if you have a spent conviction or a finding of guilt where the court didn't formally record a conviction, if you're being sentenced for an offence that you've subsequently committed, the court will still be allowed to know about that and can take it into account. Question, will spent conviction show on your criminal record? No, because a spent conviction is not part of your criminal record anymore, okay? It will show on the record that the court gets, right? Which is perhaps a different version to what the rest of the world will get. Okay, next slide, please. Okay. So there's a whole lot of ways in which a conviction or a criminal record can affect you. I haven't got time to go into too much detail about all of these things right now, but these are just some of the things, and I might run through them quite quickly. I should also say that even a non-conviction, even a spent conviction or something where you were never convicted at all, might still have to be disclosed and might still affect you in some of these areas. So again, if you're not sure, if you've got a young person you're working with who's not really sure, see if you can get some legal advice, because it can be complicated. But maybe I'll just quickly run through some of these. The Child Protection Register applies to people who have been convicted of offences um, um, convicted of certain offences against children, mostly sex offences, but also serious violent offences like not just common assault, but things like wounding or causing grievous bodily harm, murder, manslaughter. I think kidnapping is one of them. So those kinds of offences, if you've been convicted, if you were 18 or over when you committed the offence, and if the victim was a child. Oh no, sorry, even if you were under 18 when you committed the offence, you can end up on the Child Protection Register. For children, if you were under 18 when you committed the offence, the court's got a discretion whether to put you on the register or not. They will really consider whether you're a risk to the safety of children, okay? For an adult, you're pretty much automatically on the register, I think, unless it's a relatively minor offence and the court deals with you under Section 10 without recording a formal conviction, okay? So the Child Protection Register basically means that you've got really onerous reporting obligations. You've got to report to the police regularly. You've got to tell them everything about not just address, phone number, any online account you have, any children that you regularly have contact with, membership of clubs, travel plans, etc., tattoos, it pretty much everything. You've got to disclose to the police and you've got to keep them up to date. So it's very, very onerous. And if you fail to keep them updated about those things, then it's an offence to fail to comply with your reporting obligation. So I've got a few clients, sort of young people who committed offences while they were young. Often it was that sort of scenario where it was consensual sex with somebody who was underage. They're on the register even though nobody thinks that they pose a risk to children, but they've got these really onerous reporting obligations. So that's a potential impact of a conviction, which is a pretty harsh one, pretty tough one. Another one could be the working with children check. And I know a lot of young people want to work in jobs involving kids, childcare, so many jobs, any kind of human services or education related job is going to involve working with children. So if you're 18 or over and you're working or volunteering in most child-related jobs, you need to get a working with children check. Now, certain kind of convictions for offences against children will bar you from the working with children check if you were 18 or over when you committed those offences. Other offences, such as offences that you committed when you were under 18 or offences against children which are not on the banned list, but, less serious types of offences, those kinds of things can mean that they will do a risk assessment on you, okay? So you're not automatically barred from working with children, but you might have to undergo a risk assessment before they give you a clearance. And if they do a risk assessment, they have to tell you that. They have to invite you to comment on, the offences, why you're not a risk to children, what you're doing now, that kind of thing. So again, if you're working with a young person, or if you are somebody who is facing a risk assessment in relation to your working with children check, again, it can be a good idea to get legal advice and get some help to sort of put together some information to respond to that risk assessment. I'll say something here about AVOs because there's a lot of, I suppose, myths about AVOs and whether it affects the working with children check. It used to, okay? So a few years ago, um, the working with children check was different from what it is now. And if you had an AVO made against you for the protection of a child, then it could affect you on the working with children check. Since that, with the current working with children check scheme, AVOs are no longer a thing. I think if you have an AVO out against you, maybe it could be taken into account as part of a risk assessment, but it doesn't bar you, okay? Oh, can we go back? Yeah, here we go. Yeah, so an AVO, as I said, it's not a criminal conviction. Sometimes you will be convicted of a criminal offence like assault or intimidation or property damage, and an AVO will be made at the same time, okay? But an AVO itself is not a criminal conviction, okay? And AVOs are sometimes made on their own, not accompanied by any criminal charges. An AVO might affect things like whether you're a fit and proper person to have a security license, and it will usually stop you from getting a firearms license, okay? Could we just go back to the previous slide? Thanks, Bridget. Great, okay. A few other ways that convictions could affect you. The NDIS worker check is quite similar to the working with children check, except it applies if you want to work in some kind of NDIS service with people with disabilities. There may be other consequences. So certain professions or jobs, such as law, for example, policing, corrections, teaching, nursing, a whole heap of types of jobs or professions have a higher standard to qualify or to be admitted into that profession or that kind of employment. And so it's possible that if you are applying for one of those kinds of jobs, that you might be required to disclose spent convictions, or even maybe if you've been charged with something, even if the offence hasn't been proved. In some cases, maybe they could even take that into account. But that's only for certain professions. Generally, for employment, a criminal record does not stop you. It doesn't bar you from getting a job, okay? So there are some laws that say you can't work with children if you haven't got a working with children check, for example. There may be a law that says, if you're going to qualify as a medical practitioner, you have to be a fit and proper person, for example, right? But getting a job at a whole range of things, an ordinary kind of office job or a job at Macca's or at Bunnings or, the vast majority of employers, there's no law that says you can't get a job or an employer can't hire you if you've got a criminal record, okay? It's really between you and the employer. Now, some employers, of course, would rather employ someone without a criminal record than with a criminal record, okay? Some employers, though, realise that some people are criminalised, young people, particularly First Nations people, people from disadvantaged backgrounds, end up with criminal records, it doesn't mean that they're, of bad character or unfit for employment. So, of course, some employers are much more willing to give people a go when they've got a criminal record. So, while you might have to disclose your criminal record when you're applying for a job, not all jobs require you to have a clean record, if that makes sense. There's a question that's come up here, and I might answer it now because it's sort of relevant. And that question is, can spent convictions come up in national police checks? So a national police check is what you usually get if you're asked to complete a criminal record check for the purpose of a job or possibly a visa application or a citizenship application or whatever. That is the kind of check that you usually will be required to do. You can apply for a national police check either through the New South Wales Police or for the Federal Police. There's an online form, there's a fee. I think you've got to go to a police station and verify your ID as well. Now, what comes back on a national police check? Usually it is just unspent convictions. So your formal convictions or convictions which have not been spent, okay? Plus, if you've got any pending charges against you, so say you've been charged a few weeks ago with assault, you've pleaded not guilty, you're awaiting your hearing, that will still come up on a national police check, right? Which seems a bit unfair because you're innocent until proven guilty. But I suppose the flip side of that is maybe an employer is kind of entitled to know that you've got a charge against you, which might result in a finding of guilt. Now, if you do have pending charges, they will show up, they'll clearly show up on your national police check as a pending charge, right? It won't appear as a conviction. So whoever is looking at that record will be able to tell the difference between something you've actually been found guilty of and a pending charge, right? Now, usually a national police check will not include spent convictions, but if you're applying for a national police check for a particular purpose, so for example, you want to apply for a job at an airport, right? And you need to have some kind of high level security clearance to apply for that job. So if that's the reason, I think when you apply for your national police check, you are asked to state the purpose why you're applying. And if you say, oh, job, at international airport or job with Department of Foreign Affairs and Trade or whatever, then I think if it's for a job or a reason which involves where they are allowed to take into account spent convictions, then what comes back on your national police check will include your spent convictions. I hope that makes sense. So usually it wouldn't, but if you're wanting a national police check for a particular purpose, then it might include spent convictions. Other potential impacts of convictions, if you're not already an Australian citizen, then you want to apply for citizenship, it might cause you to fail the character test. Or if you maybe want to sponsor a relative, to come and live in Australia, there's also a character test for you in that situation. A big one is if you're not an Australian citizen, even if you're a New Zealander and you're here on one of those special category visas and you're allowed to stay as long as you like, that still doesn't make you an Australian citizen. And if certain types of convictions could lead to your visa being cancelled, which means immigration detention and then removal from Australia. People might have heard of 501. So Section 501 of the Migration Act, that's the main section, the really nasty one, that sort of mandatory cancellation. That's usually if you've been sentenced to imprisonment for 12 months or more. But if you're on a temporary visa, like a student visa or like a bridging visa or something, there's another section which allows them to cancel your visa, and that's kind of the threshold for that is quite lower. And you can appeal against these cancellations. You can seek appeal or review, but sometimes that'll be successful, sometimes not. Overseas travel, if you, assuming you are an Australian citizen, if you want to get a visa, to travel to other countries, then those countries will grant you a visa on a case-by-case basis. There's a popular myth that, you've ever been charged with a drug offence, you'll never get into the US. I don't think it's quite as rigid as that, but certainly some countries are more concerned about some kinds of offences than others are. Also, if you're on the Child Protection Register, and you're an Australian citizen, you've got to seek approval for if you want to travel overseas. Things like insurance as well, if you've got convictions for things like fraud or dishonesty type offences, that could affect your ability to get insurance, obviously. And there's also things like voting, jury service, whatever. I'm not going to go into that right now because it's we're nearly out of time. Could we skip across a couple of slides, please, Bridget? AVOs we've sort of covered. And here we are. So on the Shopfront website, we've got a bunch of fact sheets. The one on convictions and criminal records, you're going to get a copy by email. The new version should be up on our website quite soon. There's also fact sheets on things like the Working with Children check and the Child Protection Register. If you're also interested in learning a little bit more just about criminal proceedings and sentencing options, because I think this webinar sort of assumes a bit of knowledge on your part, you also might want to browse some of our fact sheets about criminal procedure and sentencing options, just so that this all falls into place. I hope I haven't totally confused you. It's a really tricky area, so I hope I've made it a bit clearer. If I haven't made it clearer, at least I hope I've alerted you to the fact that it's really tricky, and given you a possible source of legal advice for young people that you come into contact with. Just really briefly to finish off, if you do want to refer a young person for legal advice, our criteria generally are 25 and under, experiencing homelessness or some other form of disadvantage. Now, if it's just an advice call, we tend to be a little bit blurrier around the edges. So a young person who's not necessarily homeless, they might have a job, they might be kind of doing okay. We may not be likely to act for them in court or take on a really big case for them, but we would still give them some advice if they're 25 or under and they need it. If you do want to refer a young person, we like to get calls like warm referrals from youth services, but young people can self-refer if they like. It can be a phone call during office hours, preferably. It can be an email. If it's somebody who sort of can't call during office hours, they could email us, they could call us after hours, leave a voicemail for us or whatever. Generally, what we'll do is, unless it's super urgent, they usually won't get through to a solicitor straight away. They'll usually speak to one of our students or one of our other staff. They'll take a bit of intake information and then it'll be triaged through to a lawyer and you'll get a call back. So hopefully that helps you deal with the referral process. If there's any more questions, I think we just have a few minutes left. If anybody wants to post a quick question in the Q&A, please feel free. Otherwise, if you do have any questions, is the chat disabled? Should I post it?
You can post into the chat.
In the chat or the
yeah, I also wanted
Q&A?
to let people know I've actually been trying to upload the handouts into the chat, which is the place that we can normally do it, but I keep getting an error message. I will email a PDF of the PowerPoint as well as the handout that Jane has told you about to everybody who's registered for today's webinar after the webinar finishes today. So you'll receive that sometime this afternoon.
In the chat, I've just put my email address. If you want to, if you've got any questions that occur to you and you want to email me, I'm happy for you to do that. Otherwise, just go onto our website and you'll find our generic shopfront email address. You can use that one as well. But if you want to get directly to me, then you're welcome to use my personal one. Okay, there may be one more question. Oh, it's a thank you.
It's a
Thank
thank you.
you. Good. All right.
Thank you very much, Jane. I think it was very clear, and it is a very complex area, as you've told us. And hopefully, with the reference to the other resources, if people aren't totally clear, that they'll be able to get a better understanding to the background, so
Yeah.
that yeah.
And finally, if any of you on this webinar is a lawyer or just a massive nerd, and you want a version, a document which has got references to acts and sections and things, we have a even more detailed version which was prepared for the benefit of our lawyers. And if you want to email me, I can probably I can send you a copy of that as well.
I think someone has their hand raised. Perhaps you weren't here when I mentioned earlier that we can't take audio questions. If you'd like to type it into the Q&A, then we can respond to you. We just have a couple of minutes left. If anyone does have anything else they wanted to raise.
There's one question. Oh, okay.
I think someone's provided.
I'm not interested in, if you want a copy, please email me at that address that I've posted in the chat. I'm not in a position to take down your email address now. Thanks.
And just to let people know that if they have any queries or there's something that they haven't received that they were hoping to receive in terms of handouts,
Okay.
they can email also, apart from Jane's email, cle@legalAid.nsw.gov.au, and we're happy to provide the information, and we can also refer anything on to
Okay.
Jane.
I'm sorry, I think maybe people can't see my email in the chat. So
Okay, I can send that in the
yeah,
email if
yeah,
you're happy with that,
it's fine.
Jane.
It's
Yeah.
Jane. Oh, you can. Okay. It's not in the Q&A, it's in the chat.
Yeah, that's
I
great. Yeah.
knew how to, yeah, okay, all right. But otherwise, Bridget can put it in the email she sends you.
So
Okay.
we're at time now. It doesn't look like there are any further questions. So thank you everyone very much for joining us today. And thank you, Jane, for another great and informative webinar. And we wish you all a restful
Yes,
end of year.
and crime-free Christmas.
Yeah. Yes.
Hopefully.
Yes, definitely.
Yeah. Thanks, everybody. It's an amazing turnout, particularly for such a busy time of year. So it just goes to show, I think it's a really, it is an area where there's lots of demand for advice. So hopefully it's helped. Thanks, everyone.
Yeah, that's right. Thanks, everybody. And we'll see you for other webinars that we run. So thank you for joining us today.
Thanks.
See you, Jane. Thank you.
Okay. See ya.